Friends, let us dive into conclusion of the case 370. The following are the conclusion. First one is the state of Jammu and Kashmir does not retain any element of sovereignty after the execution of IOA and issuance of proclamation dated 25th November 49, by which the Constitution of India was adopted. The state of Jammu and Kashmir does not have internal sovereignty, which is distinguishable from the powers and privileges enjoyed by other states in the country. Article 370 was a feature of asymmetric federalism and not sovereignty. Second, the petitioner did not challenge the issuance of proclamation under Section 92 of the Jammu and Kashmir Constitution and Article 356 of the Indian Constitution until the special status of Jammu and Kashmir was abrogated. The challenge to proclamations do not merit adjudication because the principal challenges to the actions which were taken after the proclamation was issued. Third one is the exercise of power by the President after the proclamation under Article 356 is issued is subject to judicial review. The exercise of power by the President must have a reasonable nexus with the object of proclamation. The person challenging the exercise of power must prima facie establish that it is malified or extraneous exercise of power. Once a prima facie case is made, the onus shift to the union to justify the exercise of such power. The power of parliament under Article 356, subclause 1b, to exercise the power of the legislator of the state cannot be restricted to law-making power, thereby excluding non-law-making power of the legislator of the state. Such an interpretation would amount to reading in a limitation into the provision contrary to the text of the article. It can be garnered from the historical context for the inclusion of Article 370 and placement of Article 370 in Part 21 of the Constitution that it is a temporary provision. The power under Article 370, subclause 3, did not cease to exist upon the dissolution of the Constituent Assembly of Jammu and Kashmir. When the Constituent Assembly was dissolved, only the transitional power recognized in the proviso to Article 370, subclause 3, which empowered the Constituent Assembly to make its recommendation, cease to exist. It did not affect the power held by the President under Article 370, subclause 3. Article 370 cannot be amended by exercise of power under Article 371d. Recourse must have been taken to the procedure contemplated by Article 370, subclause 3, if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. Paragraph 2 of the CO 272, by which Article 370 was amended through Article 367, is ultra via Article 370, subclause 1d, because it modifies Article 370 in effect without following the procedure prescribed to modify Article 370. An interpretation clause cannot be used to bypass the procedure laid down for amendment. The exercise of power by the President under Article 370, subclause 1D, to issue CO 272 is not malified. The President, in exercise of power under Article 370, subclause 3, can unilaterally issue a notification that Article 370 ceases to exist. The President did not have to secure the concurrence of the governor of the state or union government acting on behalf of the state government under second provision to Article 370, subclause 1D, while applying all the provisions of the Constitution to Jammu and Kashmir, because such an exercise of power has the same effect as an exercise of power under Article 370, subclause 3, for which the concurrence or collaboration with the state government was not required. Paragraph 2 of CO 272, issued by the President in exercise of power under Article 370, subclause 1D, applying all the provisions of the Constitution of India to the state of Jammu and Kashmir is valid. Such an exercise of power is not malified merely because all the provisions were applied together with, without following a piecemeal approach. The President had the power to issue notification declaring that Article 370, subclause 3, ceases to operate without the recommendation of the Constituent Assembly. The continuous exercise of power under Article 370, subclause 1 by the President indicates that the gradual process of constitutional integration was ongoing. The declaration issued by the President under Article 370, subclause 3 is a culmination of the process of integration, and such is a valid exercise of power. Thus, CO 3273 is also valid. The Constitution of India is a complete code for constitutional governance, following the application of Constitution of India in its entirety to the state of Jammu and Kashmir by CO 273. The Constitution of Jammu and Kashmir is inoperative and is declared to have become redundant. The view of the legislature of the state under first provision to Article 3 are recommendatory. Thus, Parliament's exercise of power under the first provision to Article 3 under the proclamation was valid and not malified. The Solicitor General stated that the statehood of Jammu and Kashmir will be restored except for carving out of the Union Territory of Ladakh. In view of this statement, we do not find it necessary to determine whether the organization of the state of Jammu and Kashmir into two union territories of Ladakh and Jammu and Kashmir is permissible under Article 3. However, we uphold the validity of the decision to carve out the union territory of Ladakh in view of Article 3A, read with explanation 1, which permits forming a union territory by separation of territory from any state. And we direct that steps shall be taken by the Election Commission of India to conduct election to the Legislative Assembly of Jammu and Kashmir, constituted under Section 14 of the Reorganization Act by 13th September 2024. Restoration of statehood shall take place at the earliest and as soon as possible. The writ petition and special leave petitions are disposed of in the above term. That's all, my dear friends. God bless you all. Continue with my videos so that you may enjoy the